Homicide fundamentals. Homicide means the death of any person caused by another person. Sometimes we think about homicide and our mind automatically goes to criminal homicide, but homicide really just does mean the death of any person caused by another person in any circumstance. Homicide, the killing of a person. In general, homicides are classified as either non-criminal homicides or criminal homicides. So those non-criminal homicides are those that are justifiable murder. Those are like self-defense, or there's some justification for it that permits, not permits, but justifies the killing in some way or another. There's excusable murder, meaning that you had to do it or there was some excuse why you did it. And if you think to our section on defenses, those terms of justified and excusable should be familiar to you in the realms of what constitutes a justified type defense versus an excuse type defense. Those justifications and those excuses would of course include the crime family of homicide, in that some of those homicides would be justified and some of those homicides would be excusable and therefore non-criminal. We wouldn't end up sending you to jail or trying to charge you for those because they would be non-criminal in nature. And then of course there are your criminal homicides, and those are the ones we're going to continue to talk about. Traditionally you think about those in terms of first, second degree murder and manslaughter. And we'll be looking at all the various degrees of homicide and how the mental states and the actions correspond to those crimes to make them into the categories that they are. A general overview of just the way that homicides look and how we categorize them. As you can see, homicide is at the top of this chart here. And then of course we have our criminal homicides, which we're going to be talking about in depth, and then the non-criminal side. So the non-criminal homicides are, of course, still homicides. It was a death of a person caused by another person, but because they're not criminal in nature, we're not going to be talking about those a whole lot in this section. We're going to be focusing our attention on the criminal types of homicide and the way that they're categorized. And as you can see here, we have murder, and then the different types of murder, and then we have manslaughter and the different types of manslaughter. And as we start talking about homicides, I want you to keep in your mind that spectrum of mental states. How we have intentional, knowing, and purposeful over on this side of the spectrum, and how we have reckless and negligent over on this side of the spectrum. Again, all of those are mental states that we use in categorizing crime, but we tend to think about those types of crimes differently. Something that's done with intention or purpose or knowingly, we think about differently than those crimes that are committed negligently or recklessly. So when we're looking at homicides, keep in mind that spectrum of mental states, because you'll see that that's a predominant feature in how we categorize the various levels of homicide is based on those mental states and of course the corresponding actions that go with it. Just a quick reminder, as we're looking at these homicide statutes and the mental states and actions that go with, the review is the formula for a statute is the mental state plus the actions equals the body of the crime. And here's where we get that big confusion. Just because the terminology is mens rea plus actus reus equals corpus delicti, and technically corpus delicti translates to body of the crime, it has nothing to do with an actual body. Just because we're talking about homicide doesn't change the fact that the formula is talking about the body of the statute, that the mental state and the actions together form the body of the statute. So just don't get that concept confused as we're talking about actual homicide cases. The common ground among all homicide statutes, what we'll see features that kind of go along every single type of homicide are the following. That a person has died. And we'll talk very briefly about this in how various jurisdictions define who constitutes a person, whether or not the ability to prove whether an actual person has died. If we don't have a body, how do we prove that somebody has died? These are factors to consider when we're looking at homicide statutes. That another person caused the death. Obviously, we're not going to charge someone for the death of another person if that death was a suicide. It needs to have been caused by someone else. And that also, opens doors about assisted suicide and whether or not that's technically another person causing the death of another person. But we're looking for these features, that a person has died, that another person caused the death, and that death was criminal. Again, we do have this whole component of crimes of homicide, or of homicides that are not criminal in nature. We have to make sure that if we are charging for a homicide falling on that criminal side, that we actually are talking about a homicide that was criminally caused. How do we know when a person has died? These offer some interesting questions about personhood. What constitutes a person? And so many jurisdictions will define whether that person has to be born. Are we talking about fetus? Are we talking about people that have been born? Are we talking about people who have taken a first breath? Are we talking about people that have a heartbeat or brain activity? Are we talking about people who are on extended life support? At what point, how do we know what a person is? How do we define that? And what constitutes being alive versus dead? What constitutes dead? Is that complete cessation of heart and brain activity? Is it heart activity alone? Are you not alive until you've formally been born? At what point are you dead? If you've been dead for 15 minutes, and then we're able to resuscitate you in some way or another, did you really die? Can we charge a person for your death if you were dead for X amount of time before you were resuscitated? If you're resuscitated into a particular state with brain dead, or you need to be on life support and able to sustain life, are you still considered dead? These are all questions that you have to consider in your particular jurisdiction in how they define those concepts of being alive and being dead. In Oregon, a human being means a person who has been born and was alive at the time of the criminal act. So if you're thinking about whether or not a person has been killed, you have to consider whether they have been born and were alive at the time of the criminal act. Further, in Oregon, here's how we determine whether somebody has died. Death occurs when an individual has sustained irreversible cessation of circulatory and respiratory functions, or when there has been an irreversible cessation of all functions of the entire brain, including the brain stem. A determination of death must be made in accordance with accepted medical standards. Now, if a medical examiner shows up to a scene and says, yep, this person's definitely died, or if paramedics are called to the scene and they end up calling death during the time that they're giving aid, or some other medical professional in some form or fashion is able to call the death, then you know that this has been made in accordance with accepted medical standards. The problem and the confusion starts to come in when we have prolonged life of some sort, when someone's on resuscitation, when they're on a ventilator, when they're on mechanical machines that are keeping them alive, or if they were maybe declared dead and then, oh, wait a second, we have a pulse, or whatever the case may be. So this determination of death can be gray in some of those more confusing situations. More just basic fundamental information about homicide. The other component that weaves its way through all the different degrees of homicide is that another person, the defendant, caused the death. So another person caused the death of the person. Cause of death. We talked a little bit about causation, proximate cause, intervening cause a little bit earlier in this term. So we have to be really careful when we're thinking about homicide cases, what that path was, which action triggered the death, and whether or not that action is a direct trigger and we can associate to the actual defendant, that other person was the cause of the ultimate death. In the case of homicides, we're again looking at those concepts of cause in fact and proximate cause. And I like these graphs because it sort of helps my mind to think about death that's being caused. So let's look at cause in fact versus proximate cause as it relates to a fact scenario so that we can kind of see how cause in fact and proximate cause are differently related to homicide, but how both can be thought of in the context of making sure that another person was actually the true cause of the death. Let's consider the scenario that A shoots B, wounding him. To escape, B jumps in a river and drowns. A's actions are the cause in fact of B's death. But for the shooting, B would not have jumped into the river and died. So if we think about this in terms of this graph, what we have is the point where A shoots B. What happened thereafter is a direct result of the fact that A shot B. If A had just walked by B and had not done anything, they'd both be just walking along on their merry way. But because the shot, that moment, that point happened, that's what caused B to flip himself over into the river and drown. So we can make a direct path from the drowning back to the point where the action happened, where A shot B. However, note that when there's a substantial time gap between that, as we're working backwards in that timeline or forwards in that timeline to see if there's that direct cause and fact, that time gap between the injury and the victim's death, that could be areas for there to be some contested facts from the defense. Obviously, the longer we have between that moment when the action happened and the ultimate death, we could start saying, well, it could have been this, and the fact that this, and this other thing, and this other thing, and it creates this sort of diversion from that direct path. So the closer in directness that we can make, the better, because then we can show that but for that action, he'd still be alive. But that direct causation, the but for, is the most direct way of showing that one person was the actual cause of that death. Now, consider that in comparison to proximate cause, which, let's take a look at the scenario here. A breaks into a house with an axe. Homeowner B dies of a heart attack, not the axe. So scared that the person broke in with the axe that they died of a heart attack. Now, but for that person breaking in the house and, I'm here to break into your house, that person would not have died. That's where we want to go with that. But for this thing, this would not have happened. What is actually a better way to think about this causation is A breaks in with an axe, there's the action, there's the point. If you break into somebody's house, is it reasonably foreseeable that you might scare some people? Is it reasonably foreseeable that of all the potential consequences that you could think, here's a potential consequence, here's a potential consequence, here's a potential consequence, you just spray out a big potential consequences. What would a reasonable person think are all the potential consequences of breaking into a house with an axe? That's the big blue circle. That's all of the things that could potentially happen. And the green certainly falls in there. A reasonable person would say, like, yeah, that's a super scary thing. You could scare someone to death. That's more of an example of proximate cause. If I can reasonably foresee that this action could potentially cause the death of somebody else, that's proximate cause. Now, ideally, we want that cause and fact. That's the stronger causation. That's the one we always want to go for. But proximate cause is not necessarily a bad thing either. That's definitely a connection that we can use to show that one person caused the death of another person. And as we think about proximate cause and cause and fact, we have to also think about all those things that could potentially happen in that timeline. So the intervening causes, the subsequent causes, and how meaningful those interventions and things that happened after the fact are in the ultimate determination of whether or not this person actually caused the death. So let's just think about these couple examples. What if A stabs B, causing an injury that will be fatal at some point? But C comes along across the dying B, he's on the ground, he's got this fatal knife wound, robs him and shoots him in the head, causing instant death. Okay, so who is the one that caused the death? Is it A, who stabbed him and he will eventually die, or is it C, who caused the immediate death? And if you're the defense attorney for A and C, you're both going to be going like this. It was him. It was him. He was already going to die. My client basically killed a dead man. You're going to be like pointing at each other. So we have to think about those intervening causes in being able to determine which person was actually the person that caused the death. And in this case, because C cut in there, intervened, and caused the immediate death, the death would be more directly attributed to C rather than A. And then think about this one. A stabs B, inflicting a serious wound, not a deadly one, but a serious one. C, a doctor, gives B too much anesthetic and B dies. So C's negligence is foreseeable. If foreseeable, is not an intervening cause, but a subsequent cause. And so let's think about this for a second. When you go to the hospital, you've been stabbed, you have a serious wound. It is foreseeable, one of those potential consequences that I can spray out there, that there's going to be some malpractice thing that happens. That's just a possibility. A reasonable person could foresee that. So if the doctor is the one that caused the death through the misadministration of some kind of drug, technically, like the one we just looked at, he stepped in there and caused the immediate death. But B would not have even been in the hospital had it not been for A, who did the stabbing. And because it's a reasonable risk that a person that goes to the hospital might have this potential consequence, the proximate cause of the death is still A. He's the one that set off this whole thing in motion. He knew that when he stabbed him, God, that guy might have to go to the hospital. He might get a bad doctor. That bad doctor might give him bad meds. But A is still the one that's responsible. Now, if your head is spinning right now, going like, wait, that's the same, it's not that. The fact is that proximate cause and but-for causation, they're just fun ways of thinking about those pathways of what actually caused this death, who actually is responsible. And honestly, the better you are at arguing, okay, well, this falls more in the realm of proximate cause, or no, this falls more in the realm of but-for cause, the better you are at those legal arguments and doing the, I like to call it mental judo. The better you are at mental judoing and really bringing out this weapon and being able to argue your point, the better off it is. There's a ton of case law out there that talks about things that constitute proximate cause directly, things that constitute but-for cause. Inevitably, if you were an attorney fighting one of these, you'd be ripping out volumes and volumes and volumes of previous case law to say, well, like, look, this similar case happened 10 times in the past, and here's what they said, that this guy is responsible, that we can say he was the cause of the death. Conversely, you're going to be digging out your volumes on the other side going, well, I found this case law that shows that this was actually an intervening cause or a subsequent cause. And really, it's the battle of the case law in determining whether or not it falls under one of those different categories. But again, I'm just introducing these concepts as like things for you to think about. If homicides in general require these things and have these underlying current that a person has died, that another person caused the death, when you approach these scenarios, you have to be thinking about those. How do we handle them in Oregon? What does the Oregon law say about who is a person? What does the Oregon say about declaring death? What does the Oregon law say about causation? Because ultimately, wherever you're practicing, that's the determination, that's the terminology you're going to be having to use. Shifting gears just a little bit, I want to go back to that concept of mental states. And this is a really great graph to show how homicides fall in that scheme. And again, we have first-degree murder, the most serious type of murder, the one that we see the serial killers and the really horrible people being charged with. That's all the way up at the top with specific intent, intentionally, purposefully. That's, you have it in your mind that you are going to commit a murder. Down, 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 we have the different type of homicide where another person has caused the death of another person, but it's because of other things like negligence, like recklessness, like something similar to an accident. And even though those are lower on the mental state scale, they're still criminal. It's just that the culpability is different. In one side, we have really high culpability. We have intention, we have purpose. And on the other, we have lower. still criminal in its theme, still criminal in its elements, but on the lower end of that mental scale. As that mental state increases in severity and toward intention, we see that that intention becomes the more prominent thing to prove. We have to prove that that intention was there and demonstrate that intention was there. And as we move up the scale, we kind of can introduce this concept of transferred intent as well. So even if your direct intent was to kill A and somehow B got killed, you pointed a gun at A, you shot the bullet, it went through the wall and killed somebody else, even though that somebody else was not the direct person, the target of your intent, we can use transferred intent to take that mental state and shift it to another victim in some cases. So an example of this would be if A shoots at B intending to kill B, but misses and hits C and ends up killing him, A is guilty of intent to kill C. We can take that if it was premeditated, pure first degree, he had it in his journals, he was planning on killing B, he had all of this stuff. Even though none of that planning was essentially for C, we can take all of the stuff that we would have used as ammunition to prove intent, motive, premeditation, all those things in regards to B, and we can shift it and take all that and transfer that intent to our victim, who is now C.